Welcome to the Center's YouTube videos. In this short video, the Center for Agricultural and Shale Law introduces you to the system of protection for geographical indications in the United States and the European Union. A geographical indication, or GI, is an indicator you can find on the product packaging. It can take the form of a name or sign. A GI is used to identify that the product originates from a specific geographical territory and that it has unique features or reputation originating from its geographic origin. AGI is generally used to identify agricultural or non-agricultural products. And more importantly, AGI protects the name of the geographical territory in which the product originates, along with the territorial uniqueness of the product against usurpation or misuse of the product. That protection can only be secured upon registration of the GI with the competent national authority. GIs are protected at the national and international levels. Internationally, the World Trade Organization Agreement on Trade-Related Aspects of Intellectual Property, or TRIPS Agreement, provides basic principles for the protection of GIs, and it applies to all WTO members, including the United States. The TRIPS Agreement provides a definition of what is a GI and requires each member of the agreement to provide legal protection to GIs against usurpation. The agreement, however, is not specific about how members of the agreement should choose to assure such protection. WTO members must abide by the terms of the TRIPS agreement, but it is up to them to decide how they want to ensure protection of GIs, generally either through specifically crafted legislation or trademark system. In the US, GIs are protected as trademarks, and the US Patent and Trademark Office allows their registration as certification or collective marks. A certification mark is generally owned by a company and shows to consumers that a product comes from a geographical territory and that it meets specified standards set by the owner of the mark. The company is the only one who can exercise legitimate control over the use of the mark. A collective mark is another type of trademark and indicates membership in a collective entity and distinguishes the geographical origin of a product. It implies that the products sold by the members of a collective entity comply with specified standards. The European GI system is more protective than the US trademark system. The main reason is that most of European member states are part of the Lisbon Agreement and the Geneva Act, which provide a higher level of protection to GIs and is wider in scope than the TRIPS Agreement. Unlike the United States, the European Union does not protect GIs through a trademark system, but through specific regulations enacted by the European Parliament and Council and transposed in national law of member states. Under the European GI system, a GI identifies a good as originating from a specific place, while a trademark under the US system identifies a good as originating from a particular company. Another difference is that a trademark is a private right and belongs to the company that created the trademark, while a GI is a collective right and belongs to any producer producing a good in the region identified by the GI. A GI cannot be used by someone located outside that area. On the contrary, a trademark can be licensed to anyone, wherever they may be in the world, because what matters is that a trademark is linked to a particular company, not to a specific geographical area. Over the years, the US and the European Union have had quite a few arguments on how GIs should be protected. According to the US, the European GI system is too protectionist and creates trade and market barriers against US food producers and exporters. According to the US, the main issue has to do with the scope of protection that is granted to GIs and the fact that the European Union is using GIs to register names that have already entered the public domain and are generic terms. Some common food names in the United States have been used for generations, and if a common name became a GI, US food producers would have to change the entire branding name and strategy, which could be economically harmful. Another major problem for the US is that the European Union is trying to impose its GI system in other countries through bilateral agreements, therefore making it even more complicated for the US when engaging in foreign trade deals. These bilateral agreements could have the impact of restricting future sales of US exported products using common names to these other countries. If you're interested in the topic of geographical indications and would like to learn more, you can visit our website at aglaw.psu.edu and consult our work products under the Publications tab.